This honorable court is now resumed. God save the king. You may be seated, please. Morning, ladies and gentlemen. Mr. Tariq James, thank you. Miss Stephanie Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, thank you. Mr. Royal Taylor, thanks, sir. Mr. Joseph McDermott, thanks, sir. Mr. Jermaine Robinson, Mr. Andre Golin, thank you. Mr. Bryan Morris, and Mr. Ted Prince. Thank you all. All present, Chief Justice.
Thank you very much. We're continuing now with the sentencing of Mrs. Stephanie Cole Christie. And yesterday we were noting that she was convicted of the sole count of membership of a criminal organization. That is based upon three things. One, her involvement as part of the discussion concerning the arson of the Torpedo Loan Company. She was part of the group that planned that activity. That evidence showed that she was part of a criminal organization. Secondly, she was part of the group that traveled from Spanish Town to Ewerton in search of ice, and as I said, that count failed for technical reasons, but the evidence nonetheless was relevant to show that she was a part of a criminal organization. And she knew that that trip involved the purpose of killing ice, should he have existed or should he have been found. In addition to that, there's the evidence of one of the witnesses in the case that she acted as the go-between between the police and the organization for the purpose of trying to elicit information from the police to know how much information and the type of information that they had on the organization at any moment in time. And that was confirmed by the evidence of the retired detective inspector who interacted with her for some time prior to her arrest. And the nature of the interaction was such that it confirmed what the witness had indicated about her. The maximum penalty for being a member of a criminal organization is 20 years. Turning now to the social inquiry report. She indicated that she was never a part of the criminal organization, has never benefited from the criminal organization, never carried out any criminal activities on the part of the criminal organization, and never witnessed any of her co-defendants behave in a criminal manner. So that assertion is actually contrary to the evidence actually adduced by the Crown. In addition to that, there's also the telephone conversations between herself and the driver of the criminal organization who gave evidence on behalf of the Crown. And the content of the conversation and the frequency of the conversations indicated that she was far more involved than she indicated during the trial and even in her social inquiry report. So despite the recorded conversations that were admitted into evidence, and despite the evidence of the retired detective inspector, both consistent with the primary witness who indicated her role and function, she is still insisting on her position that she was not a part of the criminal organization. The report indicates that Since she has been on remand, she occupies her time constructively and is a member of the choir. She works with the kitchen and salon teams at this place where she is being held. And she was of the view that she was rehabilitated, and so is asking the court to extend leniency to her to enable her to return to her family so that she would be better able to care for her daughter, who is dependent on her for support. The report also indicates that she grew up in the Spanish Town area of St. Catherine, attended school regularly, exposed to firm guidance and discipline, received adequate exposure to the principles of Christianity. She indicated at a particular point during her teenage years, she did not heed the advice of her parents. That is not peculiar to her. I suppose most of us as teenagers, when we get to that stage, we think we know far more than our parents, so that is not an unusual event in the life of anyone. She also went on to indicate that she got married in 2011, and after a few years, that relationship became quite strained. Nonetheless, that is not something to be held against her in terms of the sentencing process, but is merely to provide information as to who she is and what is her background and life to date. She indicated that she has always had an interest in community development, and that is what she has dedicated her life to, at least a significant portion of her life, organizing football matches, sports days, school uniform parties, annual summer events on Thursdays called Wet Wet. And she was also involved in feeding the homeless in Adelaide Street and Hanover Street in Spanish Town on Wednesdays. She was able to bring together a coalition of persons to enable her to continue and to fund her social activities in the communities. And the reason for referring to all of this is that her proposition is that because of her work of this nature, it enabled her or caused her to be the center of attraction. People gravitated towards her, seeking advice and confided in her. And from her perspective, Mr. Bryan was one of those persons who sought her advice and confided in her. She explained that she would provide him with encouragement and guidance for his business, his music studio, liquor store, and the block factory. She said that she continued her Christian walk and eventually was ordained as a pastor at her church, which is located in St. Thomas, and she would travel there frequently, most if not all Sundays. The point that she was making was that she would not have had time to be involved in any criminal activity because she was involved heavily in church work and social activities and community outreach programs. Her mother was interviewed, who described her as a jovial, friendly, and nice person, and willingly extended herself to help those in need. In return, and in return, people loved and trusted her. Mother indicated that though she raised her children in Spanish Town, and at times there was a flare-up of violence, her children, and in particular, Mrs. Cole Christie, were not affected because she, as the mother, was able to navigate the difficulties posed by increase in violence in the communities in which they either lived or had to navigate in their day-to-day life. She remembers her daughter enjoying going to church, being involved in sports activities, and that is how she knows of her daughter. Her sister, that is Mrs. Cole Christie's sister, described her as willingly helpful and giving freely to all those in need. And so the family members gave a positive report on Mrs. Cole Christie. The community report from the Nugent Street area of Spanish Town. Well, not many of the residents were very forthcoming, but those who spoke said that she grew up in the community and appeared friendly, and she operated a clothing store. And as far as they were able to determine, she had someone to assist her in the store. She wasn't there very often, and they were aware that she organized activities for the children of the community, but as to her other planning activities, they were unable to give any views on that one way or the other. And so the other residents who spoke formed the view that it was shocking to them to learn that she's associated with the gang, and they were expressing their opinion as to possible reasons for her motivation to become involved with the gang. And so there is the social inquiry report. As far as previous convictions are concerned, she admitted 5 previous convictions. 5 of them involved offenses of dishonesty, obtaining money by false pretenses, forgery, uttering forged documents, fraudulent conversion, possession of forged documents. The first conviction was in February of 2016, and the other 4 seem to be different counts on the same indictment since the date of the convictions, the 6th of October 2017. That was approximately a year and a half, 2 years before she was arrested. The report goes on to say that the current matter occurred 9 years after her first offense, and in the view of the preparer of the report, the magnitude of this matter indicates an escalation in seriousness of offending behavior. Also says that the offenses for which she was convicted were offenses of dishonesty, and when compared with her current matter, does not establish a pattern of offending. And having looked at a number of these reports, it seems to suggest that in the world of the probation officers, a pattern of offending is established if you have a series of convictions of the same type of offense. So they seem to make the distinction between a pattern of offending and escalation in offending. So this is regarded as an escalation, but not necessarily forming a pattern of behavior. And so I infer from that that by pattern they mean several convictions of the same kind or of the same type. So there we are. So what emerges from the social inquiry report, in my view, is that Mrs. Cole Christie has the skill sets to engage persons in different social levels and able to establish a rapport with them. And it seems as if she translated those skills into what she was doing with the criminal organization. And so this is what she was attempting to do with the retired detective inspector. But unfortunately for her, he had recently returned, as I gather, from training regarding how to interact with members of criminal organizations and trying to turn them now into a source of information rather than become a source of information for them. And so it was essentially a battle of wits over a period of time, which I say ended successfully for the police. So that is what I take from the social inquiry report and her skills. Now, given the level of involvement of Mrs. Cole Christie, albeit that she did not attend physically, well, other than the trip up to Yorkton, and then no act of violence took place there, but albeit that she did not attend upon any of the crime scenes, in respect of the offenses charged and the unindicted offenses, it is clear that she was indeed a vital member of the criminal organization, since seeking to get information from the police in a repeated and continuous manner was essential to them, because they needed to know the extent of the information that the police had on them and on whom did the police have the information, so they could make the necessary adjustments should it become necessary. And so from that standpoint, she was a critical member of the organization, and I won't say she's the only female, but the only female who has been indicted in this case. So I won't say she's the only female member, but certainly the one who has been indicted. And having regard to the skill sets that she possessed, one can clearly see that she would be of immense value to the criminal organization if she were able to utilize her skills effectively. So it seems to me then that she was a willing party to the activities of the organization. She subscribed to their purpose and made the decision deliberately to lend her skills to the organization to enable them to further their criminal purpose. Now, it means then that the starting point, all things considered, has to be 16 years. There are no aggravating factors to move up closer to 20 years, and I take into account that she has a teenage daughter, take into account that she has skills that are outside of the criminal context valuable, and I take into account that she herself did not commit any act of violence herself. But nonetheless, having regard to her role and function and the seriousness with which these offenses must be taken, the mitigating factors such as they are not sufficient in my view to reduce it below 14 years. So you go down 2 years from 16 to 14. And she has been in custody 4 years and 2 months. So that leaves you with what? 4 from 14, that's 10. And then, so that's 9 years and 8 months. Yes, I think. 9 years and 10 months. 9 years and 10 months. Yes. So, Mrs. Cole Christie, the sentence of the court is 9 years and 2 months on the count, which charges you with 9 years and 10 months on the count, which charges you with being a member of a criminal organization. So that is it, ma'am. Mr. Tariq James, that's you? Okay, so we're now going to be dealing with you, sir. So, Mr. James was convicted after a contested trial on counts 2, 7, 8, 11, and 12. Yes. Yes, Mr. James was at the house when at the house of the accountant when the plan to kill Outlaw was developed. It was Mr. James who Mr. Bryan had sent for the firearm, and he was identified as the person who would do this particular killing, and he clearly facilitated the murder of Outlaw by not just by getting the gun, but by being willing and able, but he also returned and proclaimed to those who would listen that he was the person who actually killed Outlaw. So, based upon that evidence, we have the person here, or at least one of the persons here, who actually shot and killed Outlaw. This is in relation to counts 11 and 12. So in respect of count 11, Mr. James facilitated the conspiracy by being a part of the plan, procuring the weapon, and indicating his willingness to be the instrument by which Mr. Outlaw met his death. And in addition to that, Inspector of Count 12 facilitated the actual commission of the murder by being the person who did the actual killing, if we accept the words out of his own mouth, that he was the person who shot and killed Outlaw, and there is no reason not to take him at his word. In respect of counts, and before I get to count 7 and 8, the evidence in relation to counts 11 and 12 would demonstrate that Mr. James is a part of a criminal organization. He knew that one of the purposes of the criminal organization was to kill, to murder, to shoot or shoot at, and he would have gathered this, well, just by simply getting the firearm, because what else are you going to be using a firearm for in the context of a plan to kill someone? In respect of counts 7 and 8, Mr. James was present in the vicinity of the church and the house when Mr. Bryan was there and spoke about shelling down fisheries. He was there when the Molotov cocktails were being prepared. This is the gas, the bottles, the sand, the wick, and which would mean that even before the group left from the vicinity of the church and the house, he would have known what the purpose was for them to go over to fisheries. And he was identified as among the group of persons who left with the driver to go over to fisheries. So all of this would show that Mr. James facilitated counts 7 and 8 by making himself available and participating in the plans to go over to fisheries, to kill and to burn down the property. He also, by his presence and indicated willingness to participate, provided encouragement for the others who were there. And from that standpoint, at times, let's say there is strength in numbers, and where there are numbers, one may feel more emboldened than one would normally be. So that is his involvement in counts 7 and 8, and those counts would demonstrate that he is a member of a criminal organization. We already know that the maximum penalty for membership under facilitation offenses is 20 years. As far as the social inquiry report is concerned, He was advising the probation officer that he knows nothing about the murders or arson, and he was challenging the accuracy and credibility of the prosecution witness, and he's hoping for some leniency in sentencing. He disclosed that he was originally from parish of Clarendon, and although he had no relationship with his biological father, his mother was firm on discipline and also ensured that he attended church regularly. Unfortunately, his mother passed when he was 11 years old, leading to depression on his part, and he's still apparently grieving the loss of his mom. Relocated to Jones Avenue in Spanish Town to live with his aunt. Though he had no relationship with his biological father, he formed a bond with a gentleman who became his stepfather. And that gentleman revealed that he shared a very strong bond with him since Mr. James was 9 years old. He said Mr. James grew up in the church and was even excellent at praying. He said that after his mother's passing, then went to live with his aunt, and the stepfather and Mr. James lost contact with each other. And so he's saying that he can't speak with any degree of certainty as far as his associations in later life are concerned. The community report in Jones Avenue, those residents who responded said that Mr. James is not a known troublemaker. They were apparently aware of the death of his father and the death of his mother. And they say that from time to time they would see him in the company of some of his co-defendants, including Mr. Bryan, and they've took the view that he had to become involved in the gang activity because refusing to do so would place his life and that of his family in danger. And they said that they expressed sympathy for Mr. James since he seemed to have been a victim of forces greater than his ability to resist. And they say he's not a bad person. So that was what they had to say about him. As far as previous convictions are concerned, he has one in 2018. 3rd of December, was fined $30,000 for malicious destruction of property. It's not clear the details of that conviction, but a conviction nonetheless. The probation report says that this current offense represents an escalation in offending behavior, but it does not establish a pattern of identifiable offending at this moment in time. So we're told that he's 24 years old now. At the time of the offenses, he was under 18 years, has been in custody 5 years and 9 months. Emphasized in the plea mitigation that he's not a troublemaker. All the positive things that were identified in the report were highlighted in the plea of mitigation. Just said that he spent a number of his youthful years behind the bars, and the sentence should be one that permits him to be incorporated into society. And the suggested starting point was 10 years. And with a consequential reduction, it is said, for time spent in custody and any other reduction that may be had by way of taking into account and giving effect to the mitigating factors. Now, in looking at this to determine the starting point, we have to look at the fact that overall what we are looking at is circumstance in which, despite his youth, it can't be too, well, let me rephrase that. He would be old enough to discern clearly the difference between right behavior and wrong behavior. And to be so willing to be a part of a plan to go and kill someone is at the very least, at such a young age, is at the very least disturbing. And then to return and say that he actually carried out the attack on the individual is distressing, to say the least. And when it is into account that in this particular case, not that it justifies the killing of anyone, but as far as the evidence is concerned, Mr. Outlaw was just simply an ordinary citizen going about his daily activities, trying to make a living from the sale of phone cards and burning of coal and the selling of coal and so on. So why should a person like that just simply be shot and killed because somebody decided that his life should end now? So this is not a case of a fight. This is not a case of a spontaneous response to a provocative situation. This was a case of a premeditated killing, where you decided that you would be the instrument by which the person would be killed. So the fact that you may be 18 years or younger is of really very little concern to me at this point, at the time when these offenses were committed. You're old enough to know that what you were doing was wrong, and you made that choice to go and kill a citizen in broad daylight for no apparent reason. But let's just suppose, for argument's sake, that that was aberrant behavior, clearly unusual, out of character. Counts 7 and 8 demonstrate that this is now, at the very least, a lifestyle that you are willing to embrace. If you do not wish to say it is yet a habit, but certainly a lifestyle that is willing to embrace, because he was present when Mr. Bryan was planning to go over to fisheries to commit mayhem over there. He would be present when the guns, or what appeared to be guns, were being distributed or persons were armed with guns. He would have been present when the Molotov cocktails were being either made or gathered together for transportation over to what eventually became the crime scene. So this suggests to me that the public needs to be protected from persons who have or are developing this way of life, because the way of life is one in which the human rights and the right to life of others is not respected at all. Wanton disregard for human life and the property and the dignity of other persons. So as I said yesterday, I will never say that anyone can't be rehabilitated, but that has to come about by a personal decision that one makes. No sentence in and of itself can rehabilitate anyone. In fact, a sentence can never rehabilitate anyone. Rehabilitation can only come when a person says, having looked at my life, I think it is a terrible life that I have been living. I want to change, I desire to change, and I am now going to change. And you begin to take the incremental steps in the direction of change. That is how one becomes rehabilitated. So until that day comes, no rehabilitation can take place. What can happen is that if you interact with the probation officials often enough, unless you are brain dead, you will learn the language and the vocabulary, and you will know what to say, how to say it, to look appropriately penitent, to convince persons that you are now reformed. So this is not about retribution, no, but it's about keeping society safe from persons who have apparently adopted the mentality and behavior pattern of Mr. James as manifested by his behavior in counts 11 and 12 and counts 7 and 8, and consequently lending himself to be a willing, active member of a criminal organization whose purpose is to commit murder and arson to further their aims. So now, where does that leave us with the starting point? As I indicated, Mr. James returned from his activity as outlined in count 11 and 12, and to proclaim that he was the one who shot Outlaw. So as I said, I'll take him at his word. And so, in respect of count 12, yes, the starting point is 17 years. That is facilitating the murder. And it's starting there because, as I said, he said he killed the gentleman. So it's starting there. In respect of count 11, this is the facilitating the conspiracy to commit murder. We started 14 years. In respect of count 7 and 8, these were the offenses in which Mr. Jermaine Bryan and Miss Walker, Walder. I keep saying Walker. I've been saying Walker since yesterday. Okay, thank you. Miss Walder were killed, and also where the house was burnt down. Now, the evidence wasn't clear that Mr. James himself was there at the scene, shooting and burning, but nonetheless, his activities before indicated that he was a facilitator of these crimes. And so, since it wasn't clear whether he was present, the starting point there is 12 years. And in respect of count 2, membership of a criminal organization of this nature, the starting point there is 16 years, because he knew the nature of the organization that he had joined and was more than happy to be a card-carrying member of this organization. Nothing there to increase the sentence, that is the aggravating factors. As far as the mitigating factors are concerned, we'll take off, largely because of his youth, take off 2 years. So in respect of count 12, down to 15 years. Count 11, down to 12 years. Counts 7 and 8, down to 10 years. And count 2, down to 14 years. Other evidence or relevant information is that he has been in custody, I recall it was 5 years. 5 years and, yes, sir? And what? 11? I see. Well, it was indicated to me that it was actually 5 years and 9 months. And you are saying that you were taken into custody on the 7th of November? Okay. All right then. All right then, sir. Just hold on a moment there. Right, so Ms. Reed, you agree with his calculations? Well, I suppose it's you round up. So, yes.
I'm being told it is June 2019 that he was taken into custody for this matter. So he was in custody for something else prior to that.
Oh.
Yes.
Okay. Mr. James, you can stand, man. What the prosecution is saying is that you were in custody in relation to another matter. You agree with that or you don't? And that was from the November. Okay, okay. So, and that was in November. And then the June of the following year was when you were arrested for this. Okay, you were charged for this particular case. And you are saying now that your understanding was that the firearms case and this case would be joined together. I see. I see. That was another judge? I see what you mean. All right. Thank you very much. Yes, Madam Crown, you know about this?
I cannot speak to it, my lord. May I have a moment to get some instructions?
All right. Let us. Okay, we're just going to hold off a moment there, Mr. James, to get the correct information. Yes, Counsel? Yes. I see. Okay. So we're out by a month, you're saying? Okay. All right then, sir. Okay. Well, Madam Crown, do you agree with that in relation to Miss Christie?
I was focused on treating with Mr. James. I did not hear what the friend said.
What counsel is saying is that in respect of Miss Christie, we're out by a month. But that's what he's saying.
Yes, my lord, I'm hearing you.
So, because she was taken into custody, you said when? June 2019.
As opposed to July. Crave your indulgence, my lord.
Okay, so we'll get that for complete accuracy then. So while those two precise dates are being sorted out, yes, sir? Sorry, raise your voice and speak again. Okay. Could you repeat what you were saying there, Ms. Reed? November 17. Okay.
My lord.
Yes, counsel.
My instructions are that he was taken in for the gun court matter on an earlier date, and that gun court matter is now one of the counts on this indictment. So he is correct. That is as it relates to Mr. James. We're still checking on Mrs. Christie. Did he tell you which count it is? It is one of the uncharged, unindicted. It seems I misspoke, my lord. It is not on the indictment, but it is one of those unindicted offenses. So my friend is correct, and Mr. James is correct.
That is what the firearm that was recovered from, or said to have been recovered from over in St. Catherine.
The very. Yes, my lord.
Okay. And the date of recovery of that firearm was, and his arrest, because he was arrested the same day? Okay, and the date was when? Okay. And that would mean that he'll be in custody how long now? Four years and, well, five years. 5 years. Let's call it 5 years and 11 months. Okay. All right. So I think it is now that I may inquire of counsel here now. So would it be accurate to say that it is now agreed between the Crown and the defense that he was taken into custody in November of 2017 in relation to this? Is it a rifle or a long gun? What gun was that? Because the only other firearm that I'm aware of, you had one that was a long firearm and one that was supposedly taken over to the Caymanas. Also, what other firearm is there in this case? Apart from those with Mr. Royal Taylor. You have Mr. Royal Taylor, the firearm there. Then you had a long firearm that initially came into evidence, then came out because of the discrepancy between the writing on the exhibit box. One was saying St. Catherine, and the other was saying Water Lane or something like that. And then there's another one where they were supposed to have gone to some yard. So where that other firearm come from? It did form part of this case.
Yeah.
For this case, it didn't form part of this case.
This is the case where we had two police officers come and give evidence. What I recall is that there was a chase, there was a throwing away of the firearm, there was a recovery. That is what I recall in respect of that matter. That evidence was laid in this court.
Yeah, but did that firearm become a part of this?
No, it did not.
Yes, so I can't recall that
It
firearm.
did not come in.
Yes.
It remained in the gun court, though
Remained in the
evidence
gun court.
was here.
Okay.
Yes.
All right, so, yes, sir. This trial it did come in as a part of the evidence. That was you are talking about the evidence of the superintendent who was trying to make the link between the what? No, I think you're talking about the superintendent, the ballistic expert. Yes, and he was talking about the firearms and the spent shells from different scenes and so on. So I think that is what you may be referring to. But the actual firearm there in that case did not become a part of this case in that sense. So
belaboring the point, no one was charged in respect of this case until 2019. And Mr. James is talking about 2017.
yes.
Yeah.
So, well, Mr. James has a vested interest in seeing that
That we're correct.
Yes.
Accurate.
yes.
Yes, my lord. So, my lord, we're back to 5 years and 9 months and 8 days?
5 years and 9 months, yes.
Yes, my lord.
So we'll be settling at 5 years and 9 months. So that is what we'll be deducting now from in respect of count 17, take away the 5 years, that's 10, so that's count 12.
Count 12.
Count 12 is now 15 years.
So that would be 9 years and 3 months?
That's 9 years and 3 months. In respect of count 11.
7 and 5 is 12. So 6 years and 3 months, my lord?
No, count 11.
Yes, my lord.
So you take away you're gone down to 12 years. So that's 6 years and 3 months. In respect of counts 7 and 8, we're down to 10 years, so that's
4 years and 3 months.
4 years and 3 months. And in respect of count 2, we're down to 14 years.
That's 8 years and...
So that's 8 years and 3 months. Right. So now, right, so this is the thing now, Mr. James. As I said, I keep in mind your youth, but I have to take into account that in this case, you are actually responsible for the death of a citizen by your own hand. And so that would have been a murder trial, but for, as I said yesterday, the practice and procedure that we have that did not enable a single trial with both offenses being tried in the same court at the same time on the same indictment. So that has to be factored in as well. So, in respect of counts 2, 7, and 8, as counts 2, 7, and 8, those sentences to run concurrently. Got that, Mr. Registrar? Okay. Clear on that, Council? Counts 2, 7, and 8 to run concurrently. Yes? Now, in respect of counts 11 and 12 now, those two counts, the sentences on those two counts, yes, to also run concurrently. That is 11 and 12. Yes? And then the sentences now on counts 11 and 12 to be consecutive to the sentences on counts 2, 7, and 8. So let me repeat. Sentences on counts 2, 7, and 8 to be concurrent. Sentences on counts 11 and 12 to be concurrent. And the sentences on counts 11 and 12 to be consecutive to the sentences on counts 2, 7, and 8. And that gives us a grand total of right. So that's 17 years and 6 months, Mr. James. Thank you very much, sir. Right. So this takes us, oh, sorry, you need your break. So we're going to take a break now until midday. So we rise now.
Stand, please. This honorable court rises until 12 noon. God save the King. You may be seated, please. Gentlemen, Mr. Fabian Johnson, Mr. Fabian Johnson, supposed to be over that side, supposed to be on there, yeah. Mr. Jazeel Blake, Sir Blake, this year. Mr. Royal Taylor, thank you, Sir Taylor. Mr. Joseph McDermott, thank you, sir. Mr. Jermaine Robinson, thank you, sir. Mr. Andre Golin, thank you, Mr. Golin. And Mr. Ted Prince, thank you. All present, Chief Justice.
Right, Mr. Fabian Johnson. Yes, you were convicted on one count of being a member of a criminal organization, and that was based on two things. One, a part of the discussion with respect to the burning down of the Torpedo Loan Company building in Spanish Town, and you were on the trip up to Ewerton, St. Catherine. This is in respect of count 25 regarding the gentleman known as Ice, the person who you all went to look for, but which, as I have said repeatedly, the Crown failed on that count for technical reasons, but the evidence would still be relevant to the question of whether you're a member of a criminal organization. As we now know, the maximum penalty is 20 years. As far as previous convictions are concerned, it's none. As far as the social inquiry report is concerned, the report indicates that you grew up with your mom, Maxfield Avenue, Kingston, and your mother exposed you to good morals and values, ensured that all your basic needs were met. You would interact with your father largely on holidays and on weekends. And apparently he was a man of a mature age, since at the time you say he was a pensioner at the time when he became your father, or shortly after he became your father, and so his ability to contribute financially to your needs was limited. Both your parents have now passed, and you are now the father of 2 children. Your cousin described you as a family person, quiet, an introvert while growing up. And she even indicated that should you be given a non-custodial sentence, she is prepared to support you outside of prison. And because she is desirous of my words now, not hers, giving you another opportunity. And she, of course, is speechless and can hardly come to grips with how you have found yourself in this position. Nonetheless, she's asking for leniency. The probation officer went to the community of Denham Town, and persons were not forthcoming with much information, but I suppose the probation officers, using the skills that they possessed, were able to persuade a few of them to share whatever information they had of you. You're regarded as a jovial person who enjoyed the company of your friends. And at some point, they said that your family members had relocated from the Denham Town community and they didn't know where they were. In respect of Nugent Street in Spanish Town, the residents say that you lived there for a very short time, but they don't know much about you since you're not from the community, and therefore they're unable to speak to your character. So what this is suggesting then is that there's not much information from the community to indicate or give some indication, or to indicate or to give some indication as to who you are and the type of person that you are. You have no previous conviction, so that counts in your favor. You are 33 years old, and the evidence, such as it is, does not disclose that you were as heavily involved in the organization as others. And being a part of the two plans now, one to burn down the building and one to travel up to Yuaton to look for ice, those are the two instances that the prosecution relied on to establish that you're a member of the criminal organization. The proposition being that persons do not do these things unless they are affiliated with or part of a group, three or more, as it turned out in this case, that would form a criminal organization. And the discussion about arson. Arson is a serious offense for the purpose of the Criminal Justice Suppression of Criminal Organizations Act. And so too is going to look for someone either to murder them or to shoot them or to wound them with a firearm. And the evidence disclosed that what weapons were taken that appear to be firearms from Spanish Town up to Yuaton. Okay. And so, on that basis, then, you'll be sentenced, sir, as a member of a criminal organization. Now, what is an acceptable starting point in the circumstances of this particular case? I think an appropriate starting point is 11 years. You have no previous conviction, and consistent with that, there is no indication that this is an escalation or that you are a habitual offender. So, That would move us from 11, 3 years down. That's to 8. And then you have been in custody 4 years and 3 months. So that's 4 years and 3 months from 11, from 8. So that's 3 years and 9 months. So, Mr. Johnson, sentencing is 3 years and 9 months for being a member of this criminal organization. Thank you, sir. Now we come to Mr. Jazeel Blake. Well, Mr. Blake, you were, yes. Yes, Counsel. Or you wish to deal with him now that you are here? Okay, very well then. All right. The counsel who represents Mr. Prince and Mr. Johnson has asked that Mr. Prince be dealt with now that he is here. Suppose this is to facilitate his departure in the earliest possible time. So we'll accommodate counsel by doing that. So Mr. Prince, was convicted on counts 2 and 19 after a contested trial. Count 2 is the count relating to membership of a criminal organization, and count 19 relates to the facilitating conspiracy to commit murder of a person unknown. The evidence that has led to this conviction showed that Mr. Prince was involved in the shooting at the fisheries across the road from the National Police College. The evidence from the accountant was that the accountant and Mr. Blake were to drive down to fisheries to determine whether the targets were there. At some point, Mr. Blake made a call back to whomever, and the accountant, speaking from his side of the conversation, said that Mr. Blake was indicating to whomever was on the other end of the conversation that the targets were there. The accountant went on to indicate that Mr. Prince arrived and at some point began to shoot, presumably at the intended targets. He returned to Jones Avenue, that is Mr. Prince, where he reported to Mr. Bryan that the intended target was not shot, but somebody else was. In addition to that, Mr. Prince was also a participant in the burning down of the Torpedo Loan Company building. That plan, we know, was hatched by Mr. Bryan and others, and Mr. Golding and Mr. Prince reported to one of the witnesses that they were the ones who broke in and set the place afire. In addition to that, there was the incident in relation to the Rastaman who was killed on Jones Avenue. And Mr. Prince's role in that was to secrete the firearms from Mr. Whiteley and Mr. Morris after the shooting. So all of that now would go to show that he was part of a criminal organization. And in respect of count 19, he agreed with Mr. Bryan to shoot this unknown person. And so all of that now would show that he's a member of the criminal organization. The cumulative effect of all of this would show that Mr. Prince was very much aware of the nature of the organization of which he willingly and voluntarily became a member. It is manifested by his going down to fisheries to do the shooting, his agreement to shoot this unknown person, Mr. Bryan, and to assist with the secretion of weapons after the shooting of the Rastaman. So he's not a man averse to the use of firearms to commit, at the very least, shooting with intent or even murder. And of course, he had no difficulties with arson as well. All of them, whether it is murder, whether it is facilitating conspiracy to murder, whether it is facilitating arson, all of those are serious offenses under the Criminal Justice Administration, Criminal Justice Suppression of Criminal Organizations Act. And so, Mr. Prince, we can safely conclude, was an ardent member of this criminal organization. As far as the social inquiry report is concerned, he insists that he knows nothing about any gang, not a member of the gang, and his position is that this came about, that is, this present charge came about because he was framed by the police while on remand for another matter. He shared that he likes parties, dances, and likes to play football. Now, he indicated that both his parents were firm disciplinarians and committed caregivers who enforced Christian tenets to guide his conduct. He said he attended school regularly, and even if financial resources fell short, he was not greatly deprived. That is his view of the matter. He says his parents formed the view that he should learn a skill, so he was transferred to a vocational skill center, and in addition, he was taught shoemaking skills by his father. He also reported that his parents kept a watchful eye on him and warned him against some of the peers he associated with. Even gave him early curfews to be off the streets. He, however, agrees that he did not always agree with his parents' instructions and would fall prey to waywardness. So what is clear up to this point is that this is not for want of effort on the part of his parents to steer him along the straight and narrow path. He indicated that he lost two of his older brothers to violence, and he was angered by their passing, but counseling assisted him in coping with his grief. It was remarkable that, having regard to the efforts of his parents and his own experience of having to suffer the loss of relatives, loss to violence, that he himself has now found himself here. And his father indicated that, if he may say so himself, he was a devoted father to his children, did everything in his power to keep young Mr. Prince away from trouble. But the father observed that for whatever reason, he gravitated towards wrongdoing. Father even related that on numerous occasions he would take young Mr. Prince to the police, presumably for the police to have words with him, but nothing seemed to have worked. So we have the parents trying, police trying, efforts to make him financially independent by giving him a skill so which he could earn, but it appears that none of that was going to stop Mr. Prince from ending up where he now is. Father even shared that at one point, some of the persons with whom he's on trial with here were meting out violence to him, and his father had to rescue him. And when his father raised with him the subject of his associations, he denied that he was associated with the persons whom his father thought he was associated with. And of course, as all responsible parents, he is heartbroken and disappointed over his son's involvement in the matter. As far as the community is concerned, this is now in the Jones Avenue community. Residents say that he's a good person, gets along well with people, and from a decent home. And other persons just simply sighed and turned away their heads when they were asked about Mr. Prince. But similar to one of the reports made earlier, the residents say that yes, he's a member of the gang, but he was not a member of his own free will. He had no choice. And others did not take such a benign view of the matter. So there we are. In the case of Mr. Prince now, the report indicates that he has 3 previous convictions. Well, really 4. Housebreaking and larceny, this is in 2013. An illegal possession of firearm, illegal possession of ammunition, both of these on the 18th of July 2018. And of course, the most recent one being the contempt of court. So that is the previous record of Mr. Prince. According to the probation officers, does not represent an established pattern of offending. But this most recent conviction represents an escalation in the seriousness of offending behavior. So, in sentencing, so far, we have tended to ignore the previous convictions. But in the case of Mr. Prince, having a conviction for illegal possession of firearm and ammunition is really not a wonderful thing. And not only has he been convicted of illegal possession of firearm and ammunition, the evidence discloses that he has no difficulty either gaining access to or willingness to use them when he has access to them, or attempting to use them, as exemplified by his statement when he returned from the planned operations by the National Police College. So that shows, well, the probation officers don't regard it as a pattern of offending. But as I said, drawing the inference from how they have written their reports, pattern of offending for them seems to mean multiple convictions of the same type. So they seem to look just at the stated offense for which the person was convicted and don't go behind to look at the circumstances. So a criticism is just an observation. But looking at this now, when you see that the person has been convicted for illegal possession of firearm and the circumstances of this case show the use of firearm or secreting firearm to hide them from the police after they have been used to commit a murder, that is in respect of count 15 outlaw. So that is a matter of concern. So that tells me that Mr. Prince, at the very least, is a public health risk. He endangers the lives and safety and well-being of persons. And usually persons with illegal guns are up to no good. A gun has only one purpose, and that is to point and to shoot, whether human beings or animals. So that is how now we have to look at Mr. Prince. And it appears that the efforts of his parents did not bring about the desired results. So we are where we are. And so we have to deal with it accordingly. So Mr. Prince decided to be part of a criminal organization that made use of firearms either to shoot at or to shoot persons. And he himself was not averse to doing the shooting himself, if required to do so, or even agreeing to do the shooting, which is really what count 19 is about. He agreed to do the shooting. So, I think we can safely conclude that there are no mitigating factors here on the part of Mr. Prince. And one of the options available to the courts is the commencement time of the sentences that we're about to impose. Is currently serving a sentence now of 8 years for the illegal possession of firearm and 4 years for the illegal possession of ammunition, and both of those sentences were made to run concurrently. Now, bearing in mind, as I have said, that Mr. Prince seems to be a public health risk to the life and limb and safety of others, he needs to be away from members of the public for a significant period of time. And so, in respect of count 2, the starting point would be 16 years. No aggravating factors for it to go up, no mitigating factors for it to come down. So it's 16 years. In respect of count 19, the same 16 years. Nothing there for it to go up, nothing to come down. Now, both these sentences are to run concurrently. And the remaining question now is when they should commence. And I'm of the view that Mr. Prince's time should commence at the end of the current sentence that he is serving for illegal possession of firearm. So that is when this sentence is to commence. It's 16 years on both counts, to commence at the end of the sentence for the illegal possession of firearm. And so that is it, Mr. Prince. Yes, to commence at the end of the sentence that is currently serving for illegal possession of firearm. Right. So where were we now? With Mr. Blake? Yes, we were at Mr. Blake. Right. So, Mr. Blake. Yes. So Mr. Blake now was convicted on counts 2, 7, and 8. That is membership of a criminal organization and also the counts dealing with the death of Mr. Jermaine Bryan and Miss Sadella Walder, and the arson of the dwelling house that they were living in at the time, or they were located at the time. As indicated previously, Mr. Blake was one of the persons who went down to fisheries with the accountant to determine whether the targets were there. This was across the road from the National Police Academy. And he it was who called back to indicate that the targets were there, and this was the context in which Mr. Prince turned up and was shooting at presumably the intended target. In addition to that, Mr. Blake was on one of the trips by the accountant to kill Dooley, respect of the killing of the Rastaman. This is in respect of count 15. Mr. Blake was tasked with the responsibility of going to see whether the Rastaman was there. And in addition to that, Mr. Blake was part of the group of persons who had gathered by the church and by the home to go over to fisheries, and we know that what happened at fisheries resulted in the deaths of 2 persons. The evidence doesn't disclose that Mr. Blake, by his own hand, caused the death of any of these 2 persons, but nonetheless, he facilitated the murder and the arson by being present, giving moral, emotional, and other support to the persons who were going on this enterprise. And he was very clear as to what this mission was about, having regard to what Mr. Bryan had said before. So that was the context now that led to his conviction on counts 7 and 8. And that evidence went to show that he was a member of the criminal organization. And in respect of the trips to kill Dooley, that showed that he was a member of the criminal organization. And when he went down to the fisheries, that showed that he was a member of a criminal organization. The social inquiry report indicates that he's innocent of the charges. That is his claim. And in effect, the witness is lying on him. He agreed that there's a strong gang presence in the community and said that some of his peers were involved, but declared that he was never a part of the gang. and that the witness falsely placed him at the scenes of crimes. So that is his take on the matter. He is from the Jones Avenue community, first child for his parents, and he said he really attended school. There were constraints financially. And when he was by his grandmother, he'd be physically abused by his uncle. And thus, this is what led to him being on the streets and taking refuge there. He says the gang culture claimed a number of his friends, but he managed to survive and to stay away from it. The probation officer spoke to his grandmother, who eventually indicated that he was a good child growing up, but turned to negative association in early adulthood. She further went on to say that he was spoken to and warned on numerous occasions to cease his deviant behavior and to desist from associating with criminals and bad men in the community, but these warnings fell on deaf ears. She even added that because of his affiliations and associations, his family, including his mother, had to relocate because her life was threatened and apparently criminals made their appearance at her home from time to time. In the community itself, the residents say that he was a good youth who grew up in the community, but started mixing with the wrong crowd and was recruited in the gang from an early age. They say he's a prominent member of the gang, and some even described him as a driver. Some of the respondents said although he was a driver, he was not directly involved in the killings. Others say that he often disobeyed the leader by refusing to be involved in actual killings, and he fell out of favor with the leader. And interestingly, what some of the residents say here coincides with what one of the witnesses said, that at some point the plan was to eliminate Mr. Blake, but for some reason that plan did not materialize. So the residents continue by indicating that he has been, to use their words now, a menace to the community from an early age. And the report continues in that vein. So what is quite clear is that there are not many persons in Jones Avenue who have a favorable view of Mr. Blake. And at 33 years old to now, they have this to say. This is their recommendation. They unanimously stated that Squeeze-Eye should be punished with the full extent of the law for the offenses, and being incarcerated would relieve the burden of fear, crime, mayhem, and violence from the community. They also hope that incarceration will invoke changes in his general criminal behavior. So it is quite an indictment. And the most remarkable thing about this is that it seems as if the probation officers were hard-pressed to find even one person who could speak favorably about Mr. Blake. I mean, even his grandmother, while she was reluctant at first, eventually said, these are her words now. If he spreads his bed hard, he should face the consequences of his actions. So, Mr. Blake, it really is an indication of the life that you have lived, because normally the women, especially the grandmothers, tend to be very sympathetic. They're always the ones saying he's really not as bad as people making him out to be. They speak about all the good things about you. And so when we're at this stage where the matriarch of the family finds it very difficult to say one good word about you after the days of your youth ended, it's perhaps an indication of the life that you have lived. It really is. So, now, Mr. Blake, you have one previous conviction. This is for carnal abuse, where you were given an imprisonment for 3 years and it was suspended for 2 years, and this was in 2012. The report indicates that this is not an established pattern of offending, but an escalation of offending. Now, so what we are looking at, Mr. Blake, is a situation in which the circumstances outlined by the witnesses and what has been said by the community members actually coincide. Not often that this happens, but here we are. And so what the citizens are saying is that you're a persistent, consistent threat to their well-being, and they would much prefer you to be away from the community. So, but where would you go? Now, it was said on your behalf that you were employed as a welder and did barbering on weekends. And it is said that you want to make a more positive impact on your life of your daughter and you wish to be a role model for her. It was said that you have been in custody 4 years and 3 months. You have already lost family and the opportunity for relationship with your daughter. But it appears from what the grandmother is saying and what the people in the community are saying that you already lost your family even before you found yourself in the circumstances that you are now in, because the report says that your family members and grandmother had to relocate because gunmen were coming to their house. Inferentially, to look for you. So you, by your conduct, you have really lost your family. But what to do except to proceed to sentencing? Now, in all the circumstances here, Mr. Blake, outlining how you became a member of the criminal organization, the starting point in this case is 16 years for membership. And in respect of the other 2 counts on the indictment, the starting point is also 16 years. There's nothing to increase or decrease the starting point. So it remains at 16 on all 3 counts. They're going to be taking away the 4 years and 4 years and 3 months from the 16. And that gives us 11 and 9 months. So it's 11 years and 9 months on all 3 counts, sir. And all 3 are to be served concurrently. So it's 11 years and 9 months, Mr. Blake. And so we are now down to 4, which will complete at 2:30. We'll return at 2:30.
Stand, please. This honorable court stands adjourned until 2:30 p.m. God save the King. This honorable court is now resumed. God save the king. Be seated, please.
May it please, my lord, the matter of the Queen and Mr. Andre Bryan, Mr. Tom Rick Taylor, Mr. Michael Whiteley, Mr. Dylan McLean, Mr. Lamar Simpson, Mr. Tariq James, Mrs. Stephanie Christie, Mr. Fabian Johnson, Mr. Jazeel Blake, Mr. Roel Taylor, Mr. Joseph McDermott, Mr. Jermaine Robinson, Mr. Andre Goldin, Mr. Brian Morris, and Mr. Ted Prince, jointly indicted for breaches of the Criminal Justice Suppression of Criminal Organizations Act and the Firearms Act. My Lord, representation remains the same. We are here for the sentencing hearing. The trial commenced on September 20, 2021, and verdict was delivered in respect of these accused persons on March 8, 2023. May we have the roll call, please?
Good afternoon, gentlemen. Mr. Royal Taylor, Mr. Joseph McDermott, Mr. Jermaine Robinson, and Mr. Andre Goldin. All present, Chief Justice.
My Lord, I am in a position to indicate that when Counsel Mr. Aston Spencer indicated that his client was taken into custody in June as opposed to July, we can confirm that that is so. She was taken into custody June 30, 2019.
She come down by a month?
Yes, my lord.
Okay. She's still downstairs?
She's still downstairs? She's not, my lord.
Oh, well, we need to have her brought back then so we can make the adjustment.
She's to be brought back for the adjustment. Very well, my lord.
Yes. Okay, so we're now at case of Mr. Royal Taylor. He was convicted on counts 2, 23, and 24. Counts 23 and 24 are the offenses of illegal possession of firearm and illegal possession of ammunition, and these were found in a property to which, according to the evidence, Mr. Taylor had the keys to that particular property. Now, in respect of membership of a criminal organization, this is largely based on a series of telephone conversations between Mr. Taylor, and the driver. And the content of the conversations revealed that Mr. Taylor would have had to have had greater knowledge than he was projecting that he had. Some of those conversations could not have been taking place when you look at the nature and content and the extensive nature of the conversations, unless you are a member of the organization and knew the driver in that capacity. And so it is from the conversations that the inference was drawn that he was a member of the criminal organization. So now, the social inquiry report indicated that he is the cousin of Mr. Bryan, and he is of the view that it may be, I put it no higher than that, because of that association why he has been implicated, because he's saying that he has spoken to him, but there's nothing illegal or untoward about the conversations, and certainly he's denying that he was a part of any criminal organizations, and attribute his current predicament to poor investigative methods on the part of the police. And he has never owned a gun, or certainly not the gun that the police have produced to say that they found it in property to which he had the keys, or the keys were found with him. So that is his position at this point. He is the first of 7 children of his parents. It indicated that during his upbringing, all his basic needs were met. He was adequately cared for, and his parents made significant effort in imparting to him high morals and societal norms. He says discipline was a constant feature of his household, and wrongdoing by him or his siblings was appropriately dealt with. The value of being employable, these are my words now, not the words of the social inquiry report. The value of being employable by means of a skill was instilled in him, and he indicated that he didn't get involved in any of the usual distractions of smoking, gambling, drinking, cursing, or other negative behaviors. His mother described him as obedient, quiet, good, humble, and honest, not involved in bad company, keeps to himself, and loves playing football. Mother indicated that his behavior was good, never heard him swear, smoke, or consume alcohol. And she, like Mr. Taylor, came to the conclusion that he is implicated because he is the cousin of Mr. Bryan. Mother indicated that this has devastated her, and she is clearly very, very concerned about his current circumstances. In the community of Jones Avenue, where the probation officers went, there seems to be a pattern. Some citizens declined to speak. Others who spoke knew him since he grew up in the community with his parents, where they have lived for several decades. He was described as a nice, quiet, industrious person who owned a furniture business in the community. They indicated that he's usually so engaged and hardly ventures outside the community. And some residents said that they're not sure of any connection that he had with the criminal organization. Others state that he was not involved. Others went on to say that as far as the firearm was concerned, that was a setup, and that was because of his familial relationship with Mr. Bryan. Others said that it was an unfortunate situation. He was not liked by some persons who wanted to get rid of him out of the community because of his association or connection or relationship with Mr. Bryan. So that was the community report. As far as previous convictions are concerned, none has been recorded against him, and naturally the social inquiry report indicates that there's no pattern of offending or any, nor does this conviction represent an escalation in seriousness of offending. Now, in this case, as far as the firearm offenses are concerned, the sentencing guidelines have already established a way in which this sentencing in these kinds of cases should be approached, with the courts here in Jamaica having at least 40 years experience, nearly 50 years experience in dealing with firearm offenses. So a well-established body of jurisprudence dealing with the sentencing of persons convicted of illegal possession of firearm and ammunition in Jamaica. Now, as far as the membership of the criminal organization is concerned, we'll have to establish that in accordance with what I had said yesterday. Yes. So let us begin now with the possession, illegal possession of firearm and illegal possession of ammunition cases. And I should indicate that that this sentencing is on the basis of the Firearms Act that was repealed. These offenses arose before the new legislation came into force. That new legislation has a mandatory minimum of 15 years. That regime does not apply to the current case because these offenses took place before the new act became law, and while the repeal Firearms Act was the prevailing legislation. These kinds of offenses, there's a range ranging from 7 to 15 years for illegal possession of firearm, 15 years being reserved for the more serious violations of the Firearms Act. So for this particular case, we'll start at the lower end of the usual range, which is, so we'll start with 8 years for the legal possession of firearm, and for the illegal possession of ammunition, we'll start with 6 years. So that's 8 years. There's no aggravating factor to increase the mitigating factors are present. So in this case, he has no previous conviction of any kind, and also he has no history of offending, or naturally no pattern of offending, or neither is this an escalation in offending. The community report and the report from his family are consistent in that they did not see anything in his life or his behavior to indicate that he would be involved in activities of this nature, and so that has to be taken into account. And so the sentence in both cases comes down by 2 years, so that would make it 6 and 4. And then he has been in custody 4 years and 3 months. So that's 4 years and 3 months from 6. Remember that we started at 8. And we came down to 6. So it's 4 years and 3 months from the 6. It's 1 year and 9 months. And then for the legal possession of ammunition, we're down to 4, and it's 1 year and 4 years and 3 months from that, which would make it. There you go. Yes. So that now in respect of membership of the criminal organization, this is going to be on the lower side of the scale, certainly below 10 years. So in this case, we'll be starting at 8 years, and we deduct 2 years from that. That makes it, 6 years? And then you take 4 years and 3 months from that, which gives us 1 year and 9 months. Right, so in respect of the membership of the criminal organization, sentence is 1 year and 9 months. In respect of the legal possession of firearm, it's 1 year and 9 months. Right, and in respect of the ammunition, based upon the calculation, it really amount to no time being served. So the time that he has been in custody, that would be the time for that is really 0 days there. So both sentences on the firearm offenses to run concurrently, and the sentence along with the membership of the criminal organization to run concurrently. So all sentences to run concurrently, which means that he serves 1 year and 9 months. So that's it, Mr. Taylor. Yes. So we are now down to Mr. McDermott. Yes. So Mr. McDermott was convicted on one count of this indictment, namely count 2 of the indictment, that is membership of a criminal organization. He was not indicted on any other count in the indictment. And the basis of the case against Mr. McDermott rested on evidence in relation to counts 7 and 8. That is, he was part of the group that was on its way from the church and by the house to go over to fisheries, where the persons named in count 7 were murdered, and also the house that they were in burnt down, that formed the basis of count 8. That again is important to note. As I said, he was not indicted on any other count, so that the membership of the criminal organization, that evidence came largely from what was said about him in relation to count 7 and 8. There's no evidence that he was actually at the scene of the murders and arson, so nothing of the conduct at the scene can be attributed to him. Now, the accountant, when he was asked about how well he knew Mr. McDermott, he gave that evidence and essentially suggested that Mr. McDermott was one of the persons who would be, quote-unquote, protecting the lane, meaning Jones Avenue, by walking up and down to make sure that no one is coming in from the back, and he would have what appeared to be a firearm. So that was it as far as the evidence concerning the ability to infer that Mr. McDermott was a member of a criminal organization. Referring to the social inquiry report, Mr. McDermott took the view that the source of his current predicament was jealousy, in that the witness, in this case the driver, had some grouse against him because of being in a relationship with a lady with whom the witness himself was also romantically involved. And he's suggesting that that was a motivation for the witness to lie on him. He says he knows some of the co-defendants by virtue of weekly football games on Sunday afternoons, but beyond that, he has no interaction with them. He has no previous conviction, which means that there's nothing upon which to assess any pattern of offending or anything to suggest that this is an escalation in seriousness of offending behavior. He indicates further in the report that the relationship between himself and his father was not a very good one, and at some point his father remarried, and there was apparently an improvement in his father's relationship with him. But apparently that didn't last too long. He then ran off to go and live with his mom in St. Anne. After school, he began working to establish his financial independence, and his stepmother, well, I should not have been his mother, it should have been his stepmother. his stepmother took the decision to relocate to Manchester, and so he left St. Anne because the stepmother was in St. Anne. Went to St. Anne, the stepmother decided to relocate. He was by then an adult, and Mr. McDermott, returned to Dempsey Pen. Now his father paints a different picture. He's saying that he endeavored to lead his son to what he calls an honest and industrious life. Tried to teach him the trade of carpentry, brought him to his workshop, and endeavored to impart to him the virtues of hard work and the skill of carpentry. Father goes on to say he never knew his son to be part of a gang, and as far as he is concerned, he couldn't speak to his son's activities when he is not within his sight. That was the father's contribution to the social inquiry report. When the probation officers went to the Dempsey Pen community, they were able to say that they watched him grow up to become a mannerly and helpful person. They have not heard or seen anything to suggest that he was involved in criminal activity before now. But some community members said that they have seen him in the company of known persons who they consider to be members of the criminal organization, and that he usually accompanies Mr. Bryan, who they claim is a leader of the criminal organization, whenever Mr. Bryan visits the community of Dempsey Pen. In Jones Avenue, he's known to the community members there as a member of the criminal organization. Some persons even refer to him as a shooter. But others claim, as seems to be the pattern here, that he was forced to carry out these activities. He had no choice if he wanted to live or to spare the lives of his relatives. And the residents also added that the maternal relatives of Mr. McDermott had to flee from the community in order to avoid being killed should he not carry out the wishes of the criminal organization. So that is what we have gathered from the social inquiry report. As the antecedents are concerned, as I indicated, indicates no previous convictions. It was said on his behalf that his involvement in the organization was minimal, and that is evidenced by the circumstances upon which the Crown is relying to establish that he was a member of the criminal organization, and that he's still a young man, 29 years old. It was emphasized that no previous convictions, and that he has been in custody 4 years and 2 months. It was also said that there are no aggravating factors. So whatever the starting point is, there is no reason for it to increase because of the absence of any aggravating factors. And in addition to benefiting from the deduction of the 4 years and 2 months, his youthfulness, his industriousness, such as it is, should be taken into account, and he should be credited with further reduction from the starting point. Now, the evidence here is that he was present when the plans were being made to go over to fisheries. He was present when persons were arming themselves or had armed themselves with what appeared to be firearms, as well as the Molotov cocktails that were apparently used to set the house afire. So he was in no doubt as to what the criminal organization was about, at least on that particular evening. And his presence there was voluntary and deliberate, at least from the prosecution standpoint, though some of the residents may suggest otherwise. So in these circumstances, the starting point should be 10 years. We deduct 2 years for the absence of any previous convictions, and then that takes us down to what, 8 years? And then we take 4 years and 2 months from the 8 years, which gives us what, 3 years and 10 months? So, sentence of the court for Mr. Joseph McDermott is 3 years and 10 months on count 2. Yes, sir?
4 year and 3 months.
That's okay. I have it here as 4 years and 2 months. So that is the sentence of the court, sir. Thank you very much. Right. Now we come to Mr. Jermaine Robinson. Mr. Robinson was convicted on the sole count of being member of a criminal organization. The accountant indicated that when Mr. Bryan was by the accountant's house, Mr. Robinson was there providing security services for him. And I suppose his background made him an ideal candidate to be providing such services. The evidence is that he was a member of the Jamaica Defense Force, and so he would have some training and would have acquired some skills that would have made him a valuable member of the criminal organization. That is to say, to ensure that the leader of the organization was kept safe and sound. The evidence further is that he would be there from somewhere in the early night, 6 to 8 o'clock, till around early morning, 5 to 6 o'clock in the morning. And he was not only seen there by the accountant, but the driver also related that he saw Mr. Bryan there in his capacity as a bodyguard and providing security services for Mr. Bryan. So both witnesses spoke to that. And the recorded conversations between Mr. Robinson and the driver suggest that both of them knew each other quite well to have the nature of the conversations that they were having. And so it shows not just familiarity with each other, but they knew each other in the context of this criminal organization. And so both witnesses were able to speak to the specific role of Mr. Bryan, of Mr. Robinson, providing security services for Mr. Bryan. Now, Mr. Robinson, in his response in the social inquiry report, says that though he knows some of the persons who were in this trial, he was not involved in any nefarious activity. He explained that he grew up with most of his co-defendants and maintained a cordial relationship with them because they are from the same community. He denied being involved in an organized crime and is pleading for leniency from the court. So that is his take on the matter. The report also tells us that he is the only child from the union of his parents, and that he grew up in an extended family, his father, paternal grandparents, and uncle, who provided the main support system for him. He was exposed to societal norms and values, attended church regularly with his grandparents. His basic needs were met, and his father was a soldier, so a lot of the nurturing fell to the paternal grandparents and uncle. And of course, as grandparents tend to be, he says they were far more affectionate than his father, but that's what grandparents do. And he enjoyed the usual activities that young boys growing up would engage in, football and sporting activities. He speaks of the birth of his first child with his wife, and it would seem that that union has come under significant stress since the commencement of this case. Now, the uncle was interviewed, and he described Mr. Robinson as a good youth, not known to be mixed up in wrongdoings or associating with persons of criminal intent. Knew his nephew as an intelligent and brilliant young man who, from a tender age, took his education seriously. He has 5 CSEC subjects, 4 CAPE subjects, and he was the one who encouraged him to become a member of the Jamaica Defense Force. The uncle went on to indicate that he is not aware of Mr. Robinson being associated with Mr. Bryan or gang members. But he knows that most of the persons charged, young men charged in this case, grew up or were associated with the Jones Avenue community. And his uncle also indicated that in all the time that he was living, that is, he, the uncle, was living in the community, he has never received any complaints from residents regarding his nephew being involved with any illicit or illegal activity. The probation officers also journeyed into the Trelawney area to speak to the mother of Mr. Robinson. And as far as she was concerned, she had no cause for concern during his formative years while he was growing up, even while he attended sixth form at one of the high schools in in Trelawney, not St. Anne, in Trelawney. She says he was exposed to Christian values, attended church regularly. He was even baptized at the Holiness Christian Fellowship House of Prayer, and she regards her son as a good person even though he is charged for a serious offense. Now, there are 3 community reports. One for Jones Avenue, one for White Water Meadows, St. Catherine, and the other Holland Estate, Martha Bray, Trelawney. So in respect of Jones Avenue, this is the view of some of the residents now. They said they had a high regard for Mr. Robinson, so much so that when he became a soldier, they felt proud of his achievements, as many of the young men in that area do not normally get the opportunity to become a productive citizen. And they are known, not Mr. Robinson at this point, the others are known to be involved in gang and other criminal activities. So the resident went on to say now that Mr. Robinson, in their eyes, lost his integrity. To quote the report now, he outrightly became mixed up with the black man and his gang. There was no evidence of this during the case, but they advanced the proposition that he provided intelligence and logistical information to Mr. Bryan concerning police operations and enabled him to carry out his criminal activities. They even went on to say that he wore his JDF uniform as a disguise to transport gang members, as he claimed the police does not normally stop soldiers when they are conducting searches. So that is the view of some of the residents in Jones Avenue. As Whitewater Meadows is concerned, the few residents who were there when the probation officers visited indicated that they are not familiar with him, though they recall seeing his father entering and leaving the community, but they really didn't know much about him. And as far as Holland Estate is concerned in Trelawney, they remembered Mr. Robinson and his wife as law enforcement persons. That is how they put it. But he did not have many exchanges with them, and they attributed it to the nature of his job. So that is as far as the social inquiry report for Mr. Robinson is concerned. So what do we have here now? What we have is a young man who completed high school successfully in every sense of the word, and who persons had high expectations for, had 5 CSECs, 4 Cape subjects, became a member of the Jamaica Defense Force. All of those are positive things in his favor, which should have kept him on the straight and narrow path, because the ethos and value of the JDF certainly have nothing in common with a criminal organization. So how did he get here? Both witnesses indicated that he was providing security services for Mr. Bryan when he was at Mr. Fulton's, at the accountant's house. So the point is, how does one get to become a bodyguard? Inferentially, there would have to be some contact. It would also mean that there would have to be some arrangement. It would also mean that for Mr. Bryan to entrust his safety and security to Mr. Robinson, it of necessity meant that Mr. Bryan would have had to have gotten to the point where he reposed some trust and confidence, not just in his abilities, but also entrusting him not to bring to the attention of the authorities the location and whereabouts of Mr. Bryan. That is what that would mean. And the accountant went on to say that he was the one who would provide the firearm, or what appeared to be the firearm, to Mr. Robinson when he was carrying out his duties. So what that would mean is this, that when Mr. Robinson is going to take up his security duties, he would not have to travel with a gun, especially an illegal gun, because one of the tools of the trade would be there. So he would go, it would be handed to him, carried out the duties, handed it back, and then he would go. So if he were stopped, he would not have the firearm on him. And so because he was a soldier. It would mean, naturally, if you have your ID on you, the state of emergencies are being carried out, you have your military ID on you, it would enable you to move more easily and freely in the Spanish Town area if the police or the military were carrying out operations there. And all of this now makes Mr. Robinson's offending all the more egregious, because having been a member of the military, you undertake to abide by a particular system of values. And that system of values is completely and utterly antithetical to a criminal organization. And you made the choice to make your services available to a criminal. Now, it's an interesting question as to whether or not, in addition to protecting him from maybe members from his own organization and from other organizations, it's an interesting question as to whether you're also protecting him from the police and also from the military, but we won't speculate on that. So I think that this kind of situation now should be dealt with seriously. In the event, not just you know, but just in the event that you have like-minded members of the security force, so we don't want them to go away thinking that, you know, I can engage in this kind of behavior. And in the event that I am caught, it will simply be a very light sentence. It must be sufficient to cause them to stop and think. And if they still go ahead, then they should know that, well, since they chose to engage in that kind of behavior, then the risks are high indeed. So that is how I look at this. And when one keeps in mind the content and nature of the recorded conversations between yourself and the driver, it is clear that you were in this up to your neck. Clear as day. And your role was to provide security for a man who led an organization that engages in the business of murder, shooting, arson, and he's of the view that he could trust you sufficiently to protect his life, health, and well-being. Even though, according to the witness, when you were carrying out your job, you had what appeared to be a firearm, so he didn't have to fear whether you would use it against him. Didn't have that concern at all. So, that being the case, what is the appropriate starting point here? So the appropriate starting point here, in my view, is 14 years. Are there aggravating factors to increase it? No, we don't have any aggravating factors. Are there mitigating factors to reduce it? And some persons would say that your 5 CSEC, the 4 Cape subjects, and a hitherto wonderful life should count for something. And I suppose it does in the normal course of things. But when you embark upon a course of conduct that betrays the very core of what your occupation is supposed to be, as far as I am concerned, there are no mitigating factors at all. You can't have a soldier providing security services for a gang leader. So this is not about just deterring you now, but all other would-be members of the security forces must know that if they choose to get involved with criminal organizations, then the punishment is going to be commensurate, because it is a betrayal of everything. You are a soldier, police officers, they are the ones empowered and entrusted by the society to carry out important, yes, dangerous functions, because you are part of the persons now that stand between anarchy, criminality, and safety. And what you were doing was pretending to be on the side of law-abiding citizens and leading a double life as a criminal. That is what this is about. So it's 14 years as a starting point. And as I said, no aggravating, no mitigating factors. You were in custody 4 years and 3 months. 3 years? So where did I get 4 years and 3 months from?
Instructions are that he was taken into custody on the 13th day of January, 2020.
Your Honor.
Yes, sir.
Good afternoon.
Yeah, you have to use the microphone so I can
Yeah.
hear what.
My name is Jeremy Robinson. I don't think I know that there's an error with that part of
Oh, so when are you saying you were taken into custody?
July of 2019.
Okay.
I was locked up I was arrested at Up Park Camp. So,
In relation to this,
yes, sir.
so you were taken into custody July of 2019.
Yes, sir.
Okay. In relation to this offense, or in relation to?
Seems Millard, the JDF had him in custody.
In relation to what?
In relations to the allegations having to do with this case. And then he was handed over to the police on the 13th day of January, 2020.
I see.
Yes.
Yes, sir.
Your Honor, this was even tailored in evidence in court that Mr. What his name? One of the investigating officers came to Up Park Camp and arrested me and took me to Grand Spence. So I do not know about JDF. I've never spent any time at camp in no form of confinement. So I don't know if these people might need to be refreshed or something, or they need to get information from the relevant people, but that's incorrect.
Okay. Well, yes. So according to you, then you are saying it's 4 years and 3 months.
Yes, sir.
Okay. So we'll work with your 4 years and 3 months. So that's 4 from 14, that's 10. And then 3 from 12, so it's 9 years and 3 months. So your time says 9 years and 3 months. Okay? So that is it. Thank you, sir. So we are now down.
Was it 4 years and 3 months or 4 years and 9 months?
4 years and 3 months.
So the sentence would be 9 years and 9 months.
9 years and 9 months. Yes, 9 years and 9 months. Thank you very much. Yes, 9 years and 9 months, Mr. Robinson.
My lord, I have another pressing matter. With your leave, I'll take my leave. My colleague will remain.
Yes. Okay. So we're now down to Mr. Golding. So Mr. Golding, what is your name? Are you Andrew Golding or Dwight Golding or both? You have to remove the mask so I can hear. Use the microphone, please.
Andrew Dwight Golden, sir.
Oh, you're Andre Dwight Golding. Okay, very well, so please have a seat. All right. So, Mr. Golding, I think we have been going through the others. We have been over your involvement on a number of occasions, but nonetheless, we'll do it again. As far as the driver indicated, you were on one of the driver's trips to kill Dooley and to kill Dooley. And that it is said by the witness that you expressed the view that you could not allow Mr. Johnson to kill Dooley by himself, and you wanted to trap him. They even stopped and got a machete, which was given to you, and then the trip continued up to Price Right. So, the evidence went on to show that in respect of the burning down of the Torpedo Loan building, the accountant was directed to Rivoli to pick you and Mr. Prince up. The accountant acted as a lookout, and then when the way was clear of the police, he called you and told you that the way was clear. Sometime later, he saw fire coming from the building, and later on, you, Mr. Golding, were explaining to him how that came about, that you broke the front glass, went in and set the place afire. In respect of the shooting across the road from the National Police College, inferentially, the vehicle that was known as a duppy truck came from Rivoli, transported the shooters down to the National Police College across the road from there, shooting, drove back to the base in Jones Avenue, and then the car was taken from there by you with a pilot. Of course, the pilot was ensuring that the police were not on the road so that the car could be safely secreted down in Rivoli. All of this shows that you were an integral part of the operations of this criminal organization. Why do we say this? Because this duppy truck now, all the evidence in the case indicates that it was used in a particular manner. Whenever any shooting or mayhem was to be carried out, the vehicle would be rolled out. And then at the end of the shooting and mayhem and murder, the vehicle would be taken back and hidden. And if I recall correctly, the hiding place was in the vicinity of the Golden Age home in Rivoli. So what does that mean? That would be one of the last places the police would, unless they had specific information, it would be one of the last places they would think of looking for a vehicle, because all they would be told is that, oh, if they got any information at all, or the vehicle went down onto Monk Street. As to where on Monk Street, why would they think of the Golden Age home? And so you provided that vital transportation service for them. Now the social inquiry report tells us that you have a son and a girlfriend living in the Rivoli section of Spanish Town. And you operate a small business in the community. And according to you, now this is your account, you are saying that you had to pretend to be a part of the gang. Because if you acted otherwise, you may have been killed. Others before you who had openly opposed the gang or spoke ill of the leader were killed. So this is what you are telling the probation officer. So it is not quite clear whether you are saying, yes, I was a driver for this criminal organization and I did it because, I don't know. It isn't very explicit in that regard. But the report goes on to say that he expresses his remorse for his actions and indicated that he can only blame himself for his current circumstances. So if that is so, then when you say expressing remorse, that would seem to suggest that you are getting closer and closer to accepting that you are a member of the criminal organization and that you are now offering an explanation as to why you became a member of the organization. And, of course, the only defendant to have expressed it clearly that he gives the utmost respect to the judge as he believes he acted fairly and thus believes he had a fair trial. So didn't seem to have a problem with the process and is asking for leniency in the form of a shortened sentence and allow him the opportunity to care for his children and his current predicament. As his current predicament says was circumstantial. That is the words of the report now. So you are actually carrying out an assessment of the nature of the case against you. And not anything is wrong with that. Well, you also told the probation officer that you're the third of 5 children for your father and third of 7 children for your mom. You love playing football and engage in sporting activities. You went to the United Kingdom for a short while, and while there, you gained certification in painting and what is described here as internal decoration. So you have a skill for which you were certified. Now there's a guardian of which you speak, and she confirmed that you were living with her from you were about 8 months old. And according to your guardian, you didn't give any problems growing up apart from going out to play football without permission. She said that you went to England for some time, and when you returned, she did not notice any negative changes in your behavior. Says there was no evidence of gang affiliation, and she was aware that you had a girlfriend and a shop over in the Rivoli area of Spanish Town. And then she's trying to work out now in her way, how is it that you could come to be in the present circumstances? And she's saying, well, as far as she's aware, that area of Spanish Town, she says the Klansman gang is dominant, and possibly that's how you became associated with the criminal organization. She says you are not a criminal, and your involvement here may have been due to your business there and the girlfriend over there, as well as the child. Now the probation officers went to St. John's Road, and the citizens there described you as an honest, hard-working young man, respectful and usually soft-spoken. They worked on several construction sites. They knew about the shop in Rivoli, and according to them, you were never an idler. Well, they said in their community, there are no gang-related activities there. But they said that you are not a violent person, that is, they don't regard you as a violent person. And like your guardian, he could have been implicated due to association through the business rather than being a member. That is their analysis of the circumstance. You have one previous conviction, and that's in 2013, well, actually 2. One was larceny of a motor vehicle, motorcycle, and the other was possession of ganja. Won't hold those against you. The social inquiry report says there is no pattern of offending, and they also say that this conviction does not represent an escalation in offending. So, what is the appropriate starting point now? Well, the thing is this, Mr. Golding. You have persons who participate at different levels. Some are more involved than others, understandably so. Some provide important services. So, drivers, accountants, those who provide security services, even if they are low down in terms of the command structure of the organization, they tend to provide important services. And when one looks at a criminal organization, it's not just about the leadership. It is also about those who provide the support services that enable the criminal organizations to function. So that is why the legislation now is structured in such a way that it also targets persons who provide support for the operations of the criminal organizations. And you happen to be one of those support persons. What support did you provide? You kept the vehicle or vehicles known as the dumpy truck. You would put it into service as and when required. The whole idea being that you would have, because if you recall the nature of the evidence, the accountant would rent some vehicles. And then you had this dumpy truck that was not a rented vehicle. The evidence was that there were several of them. They were bought vehicles, and they were used for specific purposes, and also kept out of sight until they were needed for the specific purpose. And your job now was to keep the vehicle. So in addition to disabling you know the individual, as in Andre Golding, we also have to send the signal now to others. So we don't want them to think, oh man, I'm just a driver, man. So in the event that I am caught, then sentence will be very light. Yes, it will be lower than others, but I wouldn't think it is going to be a very light sentence. So it is disabling you, dissuading others. And as to whether it is going to prevent crime, I don't know of any punishment that prevents crime in and of itself. It may deter some people, but in many instances, punishment really doesn't stop crime. Courts have been around now for, goodness, hundreds and thousands of years. And if punishment had prevented crime, by now, having regard to the long history of humanity, would have had peaceful societies, would hardly be any need for the police and judges and courts and prisons and so on. So, punishment in and of itself doesn't stop crime, but what it does is that it sends a signal to you and to others of the likely outcome if you engage in a particular kind of conduct. So, having said all of that, for this kind of case and your level of involvement as the driver and the keeper and the carer of this truck, the starting point is 10 years. No aggravating features to put it up. No mitigating features to bring it down. Say I've been in custody, I've been informed 4 years. 4 years and 1 month. So that's what, 5 years and 11 months? So that's sentence of the court then is 5 years and 11 months, sir. So that is it. Mr. Golding. Yes. You're saying now it should come down by about a month, you say?
Well, yes, Your Lordship.
Okay. Okay. And Mr. Registrar, remind me of the sentence from Ms. Christie there. It was what? What remind me of the sentence there from Ms. Christie? Yes. Okay. And you are saying it should be 9 years and 9 months. Okay, so we'll make the adjustment then to 9 years and 9 months for Mrs. Christie. Very well then.
My Lord, so please, my Lord, in relation to Mr. Andre Smith, who was deceased,
Yes.
Crown and the defense, we have executed a agreed fax document for His Lordship
Yes.
in relation to this particular matter, Lord.
Okay. Okay. So just to be clear then, for Ms. Christie's 9 years and 9 months, we'll make the adjustment. Yes. Right. Thank you. So in respect of Mr. Andre Smith, this is what, an agreed facts between the prosecution and the defense? Okay. So let's read it into the record then.
Very well, my Lord.
Right, let's start up at, right up at the top. Yes.
Form 4. Schedule -PD number 1 of 2016. Agreed facts adduced by way of admissions by agreement. Pursuant to Section 31, CA, subsection 1, subsection B of the Evidence Act. Case number HCC 134/18-1 in bracket, comma, CACT 2019 CR 00212 and CACT 2019 CR 00279. In the Supreme Court of Judicature for Jamaica, in the Circuit Court for the Parish of Kingston, holding at King Street on the 25th day of September 2023. The King versus Andre Smith for being a part of a criminal organization, count 1, facilitating applicable offense by a criminal organization, count 2.
My lord, I too make an application to correct the document, my lord. He was charged when the legislation then read a serious offense as opposed to applicable, my lord. Grateful, my lord.
Facilitating serious offense. Yes.
Okay, my lord. Facilitating commission of a serious offense by a criminal organization. The following facts are hereby agreed between the prosecution, represented by Ms. Claudette Thompson, Senior Deputy Director of Public Prosecutions, and Mr. Dwayne Green, Crown Counsel, and the defendant, Mr. Andre Smith, is represented by Mrs. Alexander Shaw and Aston Spencer, attorneys at law. 1. That on the 10th day of August 2022, a body of a deceased male suffering from gunshot wounds was removed from Hagley Park Road in the parish of St. Andrew and taken to the Kingston Public Hospital, where it was pronounced dead. 2. That on the 10th day of August 2021, Detective Corporal Kadeen Grant, forensic crime scene investigator assigned to the area for scenes of crime, processed a crime scene along Hagley Park Road.
Continue reading.
3. That on the 11th day of August 2021, the said Detective Corporal Kadeen Grant attended on the Tranquility Funeral Home, where the body of the deceased male was photographed and uploaded to a DVD and assigned call-out number 2016/2022. 4. That on the 13th day of September 2022, Dr. S.D. Chana Pereira, consultant forensic pathologist, Ministry of National Security, performed a post-examination on the body of the deceased male, whose body was identified to him by Miss Valerie Morgan in the parish of St. Andrew, and opined that the cause of death was due multiple gunshot wounds to chest and abdomen. 5. That on the 20th day of September 2022, the investigating officer, Detective Sergeant Patrick, 5. That on the 20th day of September 2022, the investigating officer, Detective Sergeant Patrick Walker, visited the area for scenes of crime office, where he was given a disc labeled 2016/2022. Murder, Hagley Park Road, Kingston 11, vicinity number 78, along with the statement of Detective Corporal Kadeen Grant. Number 6, that Detective Sergeant Patrick Walker viewed the disc labeled 2016/2022 and saw the deceased body of Andre Smith, otherwise called Bowler, who was charged for the offense of being part of a criminal organization jointly with Andre Bryan and 31 others. This written statement of agreed facts is made by the parties with the full knowledge that the contents of the statement will form part of the trial of the case in court and be entered into the court record. It is signed by Alexander Shaw, Defense Counsel, and Mr. Spence, and also Prosecuting Counsel. It is dated, thank you, Judge. It is dated October 3, 2023, in all spaces provided, and also signed further by the Prosecuting Counsel and dated the 3rd of October, 2023. Completes the reading of the form, my lord.
My lord, if I may, might I just make a second application, my lord, where it referred to paragraph 2, that on the 10th day of August 2021, that, my lord, be amended to reflect 2022, and in relation to paragraph 3, where it said on the 11th day of August 2021, that too, my lord, read the 11th day of August 2020. Oh, sorry, give a moment, my lord. 2023. Lord, I crave your indulgence briefly. Yes, my lord, 2022.
As Mr. Spence is in agreement with this? Yes, Your Lordship. Okay, and also in respect of the at the commencement of the document where it says the king against Andre Smith, it should really be Andre, Bryan, and others, because that is really the name of the case.
Indeed.
And so it is really the king against Andre Bryan and others, and in interpreting it, the facilitating applicable offense should really be facilitating serious offense. And also as a matter of interpretation, the trial started in September of 2021, and Mr. Smith was a part of the trial then, so it would hardly be the case that he was dead before the trial started and still appear at the trial. So I think that is an error. It should be 10th of August 2022, so it would be interpreted and understood as referring to the 10th of August 2022 in paragraphs 2 and 3. Yes.
Very well, my lord.
Right. So, Ms. Christie, good afternoon, ma'am. Yes, so we are correcting an error here. We're told that a month is to be taken off the sentence from, it is supposed to be 9 years and 9 months, and not 9 years and 10 months. So the sentence is 9 years and 9 months, ma'am. All right. So that is it then. So thank you very much. Thank you for returning. And is there anything else?
No, my lord.
Okay. So let me thank you all for the assistance given to the court during the trial. Thanks to counsel for both the prosecution and the defense, to the police, both uniformed and those who are not in uniform, to the court reporting unit. It has been a very demanding case since we require the transcripts on a daily basis, which they were able to do. So I wish to express my appreciation to the court reporting unit for being able to do that, and to the staff of the registry that enabled us to conduct the trial within the difficulties that we had, but we were still able to get it through within an acceptable time frame, having regard to the number of defendants and the number of attorneys involved, and to express my appreciation to the superintendent who is sitting there, and to the superintendent before him, who would have been responsible for providing security down in the cells and inside the courtroom, and of course to the ICT staff from the Court Administration Division that facilitated this broadcast of this sentencing, and also the other parts of the trial that were broadcast. So thank you all very much. And so this phase of this matter is now at an end. So let's take the adjournment, please.
Stand, please. This honorable court stands adjourned. God save the king.